Ms. Johnson, did you have any?
I have a few more questions for Ms. Preble. Ms. Preble, is the state of Oklahoma expending funds to support the child at this moment?
Yes, ma'am. The mother is currently on TANF. I do not have those dollar amounts.
Do you know how long the mother has been on TANF?
Since September 10, all the time. She's never gone off.
So she's been on TANF for the entire time that our case has been open?
At least since the order. I'm not sure when the first date of the first order was.
And do you know if all of the money that is owed at this time is owed to the state?
Yes, ma'am.
It is?
Mm-hmm.
I don't have any further questions for Ms. Preble, Judge.
Okay. All right. Do you want to call Mr. Dill as your witness, or do you want him to proceed?
I'll let him proceed.
Okay. Mr. Dill?
Yes.
Judge, so can we excuse Ms. Preble?
Yes. Okay. Mr. Dill, I'm excusing Ms. Preble since you didn't have any questions of her. Thank you. Okay. Ringgold has exited the conference room. Okay, Mr. Dill, your opportunity to present evidence or testify as to why the court should not enter an order confirming the tax refund intercept.
Okay. The past due arrears debt is a lien that's against my issued SSN, correct?
Sorry? What?
The past due debt that said that I owe is a lien that is against my issued SSN with my social security number. Is that correct?
No, Ms. Johnson, did you want to reply to that?
It's not a lien, Judge. It's a court-ordered debt.
Yeah.
The debt itself is a lien that's against the social security number.
No. Can you?
That's what it says in the child support.
Really?
That's what it says in the child support handbook.
Hey, Mr. Dill, the only fact or evidence that the court is interested in is whether you have paid a sufficient amount that you owe less than $150.
I thought this hearing was to challenge if I'm the person who owes this debt or not.
Well, that's true. I don't think that you're not the person that owes the debt.
No, because the lien.
The father of this child. I thought you were
the piece of personal property that the lien is against is not my property.
Well, it's not a matter about a property debt or a lien on property. At this point, I'm not saying you can't be a lien on property or it doesn't result in a lien on property, but it's just
if we're talking in regard
to $249, you were lawfully ordered to pay $249. An administrative or district court for the support of your son. The department has kept record. Payments were to be made through the child support office, the Oklahoma Child Support Office, and they allege that you owe a little over $30,000.
Right.
And for federal and state tax refund.
Right.
At least for federal, I'm not sure. Is the state saying at $150?
Now,
I thought the state was at $50.
Now,
anyway,
if this is returns to a debt, the debt itself, like this whole hearing, the debt is a lien that's against the social security number, and I do not own that social security number, and I don't own that social security card.
You don't have a social security number?
I have a social security number, but it is issued to me by the Social Security Administration, and the Social Security Administration, they own that number and they own that card. It's printed on the back of the.
Okay.
It's printed on the back of every Social Security card.
Okay. Well, this isn't Social Security. This is just.
Right, but we're talking in terms of the debt. But we're talking in terms of the debt that you guys are saying that I owe. So therefore, child support has the burden of proof to prove that I owe this debt. Well, that debt is a lien that's against my issued Social Security number that I do not own. In order to put a lien on something, you have to put a lien on somebody's personal property. That's not my personal property because I don't own it.
Well, let me ask this, Mr. Dill. Have you paid your child support?
No, sir, because no, sir, because whenever I signed that agreement, it was because it was under coerce and duress because they were threatening me that I would be punished by law. Therefore, consent and free will is an essential element of a valid contract. If I didn't sign those by free will and by consent, then that agreement is invalid.
Are you talking about the original paternity order
I'm talking about
from 2012?
I'm talking about the paternity acknowledgement that was the offer, and I'm talking about the offer for child support services after paternity was established. Those are voluntary offers. Those were given to me in the impression that I had to do that this was a court order and that child support was of the state. Child support is not of the state. You guys are a single and separate unit, not of the state. The Central Support Registry is operated and owned by a private company that is contracted through Oklahoma DHS and Child Support, and their name is System and Methods Incorporated. And the Office of Oklahoma Management and the Office of Oklahoma of Enterprises and Management Services, they manage that contract from the private corporation to the Oklahoma Department of Human Services Child Support Division. They manage that contract. And and in my documents that I gave you the RFP that proves that allegation.
Are you wanting to have these documents that Ms. Johnson's office forwarded to the court submitted for evidence?
Yes, sir. Because this is a fraudulent case. This is a fraudulent case.
Judge, I think a lot of the documents are beyond the scope of this hearing.
No, they have everything to do with this debt. Objection. They have everything to do with this debt. Everything that I'm mentioning right now has everything to do with this debt.
I further object that it's an improper narrative.
Well, I'll note your objection and overrule it as it's documents for the record.
Okay.
Or whatever they may be.
Okay.
Whatever value they may be. So, can you summarize? You have to summarize what your objection is. In other words, what you just stated, you believe is summarized by these documents that you've submitted. Is that correct?
That's correct, and I'm also stating that the debt comes from a lien that is against personal property that is not mine. I cannot be held responsible for a debt if the lien is against property that is not mine.
Okay. Are you saying you do not? Well, I don't know. I'll let Ms. Johnson, did you have any questions, Mr. Bill?
I'll ask a few to maybe just sort of grasp a little bit of what's going on. So, hey, Mr. Dill?
Uh-huh.
Are you the father of J-Ron B. Dill?
I am.
Okay, and his date of birth is 6/15/2010, is that correct?
Yes, ma'am.
Okay. And is your social security number 4?
That is my issued number, and I do not own it.
Okay, but that is your issued Social Security number for you.
That's right.
Okay. And do you live at 63 in Tulsa?
That's where I stay.
Okay. And are you, just so we can be clear for the record, are you objecting to the tax intercept on both the state and the federal taxes?
Yes, and the stimulus check.
Okay. So all three of those. Okay.
Mm-hmm.
And whenever, on February 6, 2012, when the order determining parentage was filed, were you present on that date?
Yes, I was. I was at the child support office that day. And
Okay. And did you sign that order?
I did, but she gave me the impression that it was a court order and that I would be punished by law if I did not sign and agree to it.
Do you find that to be incorrect?
I find that to be incorrect because that is in violation of my 14th Amendment to procedural due process due to the fact that that is an offer. Due to the fact that that's an offer that's voluntary.
Okay. Now, you actually have had a contempt citation filed against you, correct?
I have, and I was unable to pay, and that is against the law according to the Department of Justice letter that was mailed out to you guys on March 14, 2016.
Now, you did serve your 6 months for the contempt, correct?
I did.
Okay. And that was in 2017 and 2018?
Yep.
Okay. Judge, I don't have any more questions for him at this time.
Okay.
I may have some follow-ups in a little bit.
Mr. Gill. I've listened to what I believe I understand what your position is.
Okay.
The court disagrees with it respectfully.
Okay.
I find that through the order that the court at second judicial notice you were found to it is your father of this child that's the subject of this matter, and 10-year-old child, almost a 10-year-old child, and so you're the correct legal father, and you were still ordered to pay $249 per month until the child's emancipated. And he's years away from emancipation. He needs to be submitted. You have that legal obligation as the biological or legal father. You're both the biological and the legal father according to these legal documents. And Ms. Pringle, as the custodian of the records and witness in this matter, have testified to the document. You presented no proof of payment. Now, and these tax refund intercepts are going to help pay on this. And it's true. The court does believe this is a debt that you owe, and
how, whenever
that it's a legal debt under state.
The piece of personal property is not mine that you guys have to lien against that's causing this debt. That's not my property. How am I responsible for a debt that's not mine that's applied to personal property that I don't own? How is that possible?
Maybe a district.
The only thing that debt is attached to is that Social Security number, and I don't own that Social Security number. And since DHS is saying that I owe a debt, they need to prove that I own that Social Security number. The burden of proof is on them. They're the ones saying that I owe.
In the court's opinion, it's not the debt against the Social Security card, it's the debt against you personally.
It's the debt. Look, you can only apply a debt. Okay, listen.
An obligation to help support this child. And so I find that there's a balance of $31,362.45.
Well, the burden of
May 20, May. Does it go through this month?
Through May, yes.
Through May, so that was last month, wasn't it?
Yes.
So
Judge, are you denying that a debt is not a lien that's attached to someone's personal property?
I think a debt judgment, once judgment's entered and you've had some judgments entered against you, that can become a lien against real and personal property. And that's just to help satisfy the debt. I mean, if you've got
the only thing that debt is attached to is the Social Security number. That's it. Without that Social Security number, just like on the document that you guys gave me, the debt is next to my Social Security number. That's all you guys have it linked to and attached to. Okay, well then this case is fraud.
If you didn't have a Social Security number,
then you guys wouldn't be able to find me in the system because you guys need the Social Security number to operate the whole child support system. Without that number, you guys can't operate child support services. It's clearly stated in the child support employee handbook. It's clearly stated. I've read all the handbook. This is fraud. This is fraud. This is fraud.
Yeah. Well,
okay.
Well, but sir, is your child a fraud? Do you know?
No, my child is not a fraud. The debt that you guys saying that I owe is a fraud because it is a lien against property that is not mine. And I've repeated myself 5 times about that. Do I need to go over the definition of a lien and what a debt is?
Okay, and Mr. Deal?
Yes, sir?
You know, this court has respectfully disagreed with you. And so I've made my order.
Okay.
And this is one step. You can
appeal it, yes.
For you, and you can file your appeal with the appropriate district court.
Yes.
And you need to do so within 30 days.
Yes, sir.
File a petition in error with the appropriate district court within 30 days.
Yes, sir.
The date that I signed the journal entry now, I don't know if I'll sign it today or tomorrow. Probably sometime this week, I would guess.
And I'm also going to sign forms with the IRS, letting them know about the identity theft and the fraud, and that you guys are illegally stealing my money. Okay.
You have a right to appeal the decision.
Okay.
It does reduce the debt that you owe. You've made other payments over the time, I believe. Is that correct, Ms. Johnson?
Yeah, there's been a few payments made. There's been some, yes.
Yeah, there have been some payments made in the past. Anyway,
Steve, and then, to be honest, this court hearing shouldn't have went as far as it did because I separated myself from the legal entity and I've separated myself into the natural person that I am, and you still continue to go on with this, and you're only able to interact with another corporation who is the legal entity, who is the name of the obligor that is in all capital names that you have on that paperwork. So I don't understand why we even continue to go through this proceeding if I already done separated myself from the legal entity. You openly admitted to that. You told me okay. But it's okay.
Mr. Deal, are you the legal father of this child? You admitted at some point in time and you've made some payments.
I said that I signed the paternity acknowledgement under duress and coerced because I was under the impression that this was of the state and of court and that I would be punished by law. That is what I was told, and that's why I signed that. Nobody told me that I could deny this and that I have to be responsible for the paternity test costs to the state. And I wouldn't be in the position that I'm in now with child support. Nobody told me that. That is my violation of my 14th Amendment right to procedural due process. Nobody told me the full terms and conditions of the program. Nobody did.
Okay.
It's a fraudulent case.
But you would have had a right to serve. You would have had a right to appeal back.
That's right. But nobody told me that either. So that's another violation of my 14th procedural due process. Nobody told me that either. Nobody told me that either.
Do you understand you have a right to file a petition in there and appeal to the...
I understand that I can appeal this decision. I understand that I can appeal this decision.
Okay. Ms. Johnson, do you have you have a correct address for Mr.?
Yes, I do have a current mailing address. He acknowledged that on the record today, Judge.
Yes. Okay. All right. Is there any? So he'll probably get the order. I mean, I'll get it within today. It doesn't need to be today. We're all under. I mean, President like.
Yeah, I mean, I have docket tomorrow and Wednesday, so I'll get it to you by the end of the week.
Okay. Okay. Now.
And Mr. Jim also needs to understand that's the appealable order. So once from the date that order is entered, his appeal time starts to run.
And what about the fact that Charlotte Stokely is a person of unsound mind and that any contract signed by her is invalid in the state of Oklahoma? And that's the fact that she's on TANF and receives SSI at the same time. You can't have TANF and SSI at the same time.
Okay.
This whole case is fraudulent. I'm trying to point that out to you guys, but that's okay. That's all right.
Okay.
Okay.
Well, all right.
So we're done here?
In order, if you don't have it, now, Mr. Bill, if you don't get this order, say within 10 days, Ms. Johnson, I will say this. If you don't have the order to me Thursday, on Friday, I'll be teleworking, and it will be, I probably would wait until Monday before I.
Okay, you prefer to have it before Friday? Okay.
Well, I mean, I give you time to think. I think I could send it, sign it, and get it back to you on Friday. So that
No, I'll get it to you. I'll get it to you before that. I know it's kind of tedious to sign all that stuff while you're teleworking.
No,
So I'll get it to you.
I'm just trying to think. I don't have a printer up here, but I don't think I need a printer because I think you'll just do it like any other order. So
Right.
Friday should be fine too. I'm on duty this Friday, so it shouldn't be a problem. So if it's June, I don't know what Friday is. It's June 6th, maybe.
I don't know.
4th.
I think it's the 4th.
Whatever. So Mr. Deal, the time begins running from the date the judgment's entered, but it'll take a couple more, it could take 3 or 4 days before you get your order, Mr. Deal.
That's fine.
So anyway, all right. But they are showing payments for you now, Mr. Deal. So that's the other side of the coin, and you can decide what you want to do in that regard. Okay. This concludes this hearing at this time.
All right, thank you.
All right. Mr. Deal, you can disconnect the conversation.